everyone to stand. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, next we have announcements. First announcement is that Scott Stilton is in the back corner and he is videoing this meeting, and it will be put live for the residents to watch tomorrow before noon. It will be posted up on the internet. Also, this meeting is being held on the Zoom platform, which there's a speaker here. So some people are here on Zoom. First up, we have our consent agenda. Do I hear a motion to approve the entire consent agenda?
I'll make motions.
Hear a second?
Second.
All in favor?
Aye.
Aye. Okay. Next up, we have departmental reports. Public Works, Don Johnson is here.
No, before Don, I'll let you know that this past week he did complete the trench drain that was required to be installed at Mount Hill, and also ordered some more storm sewer supplies that'll be used for a new small stormwater system on Reservoir Road. And I believe he's also ordering the pipe that he needs to replace the pipe here in Split. And that'll be it for the stormwater projects this year.
Okay. Thank you. Appreciate that, Steve. Don certainly does a good job. Anybody that's driven in the wintertime knows that. Item 2, Christy, our administrative assistant. She is on Zoom.
She is on.
Yeah. Oh, please.
Christy,
Breaking up again.
Yeah, I can still run right. I'm just animating. If you can't hear me.
That's better.
Oh, is this better?
Yeah, it came in better now.
Okay. I will be brief. The Honey Brook Community Partnership met yesterday, and the big topic of conversation was, of course, Harmony Day, which will be Saturday, September 18th from 10 a.m. to 2 p.m. at the Honey Brook Fire Company grounds, as well as a few other locations throughout the borough and township. The map will be published courtesy of Chester County Hospital. There will be flu shots available. There's going to be the Fresh to You mobile food market truck, car seat safety check, yoga, line dancing. Not really.
There you go. That's back.
Okay. Chester County Secretaries of Government Association met for the first time in person since a year ago, January, and so we hope to continue meeting. That's all I have.
Thank you, Christy. Sounds like a lot of fun. We have an update from our township manager, Steve Lynn.
yes, want to let you know that we did close out our DCNR financial assistance contract for the Comprehensive Recreation Parks, Open Space, and Greenway Plan. We got notice this month that we had completed everything needed to close out, and we'll expect a check for the remaining $15,000 in the grant in the next month or 6 weeks. Icedale Trail feasibility study. We have an item on the agenda tonight for you to approve change in the grant contract with Chester County. 2020 because of COVID. And because of that, before, running right up against the deadline for the funding, I did submit a request for extension, and the county has provided the necessary paperwork for all parties to sign. Apparently, the Chester County Planning Commission that the grant runs through is fine with this. And like I said, tonight, we're asking for the supervisors to approve the extension and go ahead and sign that. We'll get it back to the county. I just want to let you know that the pension administration and reporting requests for proposals to go out for two different firms, or maybe one firm who can do all the things we're asking for, will be going out in the near future. The two RFQs, requests for qualifications, were provided to both Beth and the treasurer. The treasurer approved them just a little while ago, and Beth just within the last couple of days approved them, right? And so we'll be getting the changes made, we try to get them out on the street. And the reason we're doing that is we're really not getting service from the existing vendors that we're using, and that's not fair to the township or the employees. And the other thing, and I think I mentioned this before, but it bears mentioning again, there's a new Pennsylvania Act that's going into effect the end of this month. It's called Act 65 of 2021, and it's an amendment to the Sunshine Law, and it has to do about content of agendas, when they must be posted, what to do in the event that you'd like to take action. That's a significant matter, and the item's not on the agenda. You're going to have to actually pass a motion to put it on the agenda, and then accept public comment on that item, and then go ahead and discuss the item and decide if you want to make another motion for some type of action. But it's all spelled out. There's a lot of the information on a fact sheet that we received from PSATs, and Beth has also provided this information from a law firm. I am going to be getting this out to all the boards and commissions to make sure that they're aware of this, and I'll give them time that we need to receive this at the office, so to make sure that it's on the website, because it must be posted there at least 24 hours in advance of the meeting. And because up until probably today, the only person who knew how to post an agenda to the website was Christy. And I believe that Christy just went over this procedure with Chris today, because both of them need to be able to do that. Because obviously, Christy didn't like the idea, but I said she couldn't ever leave anymore, because we need her to post agendas. So she didn't go for that. She liked training Chris instead. So that's what we're doing. And like I said, that's going to go into effect for everybody's meetings next month. That's all I have.
Thank you, Steve.
On that point with the access to the website, we first set it up by the admin, right, and I gave it back, but if you need that backup, and I can do that if you needed to post something and Christy and Chris were not available.
Thank you, John.
Okay, item 4, Land Preservation Committee. We don't have anyone here from the Land Preservation Committee. And they had
Last meeting, yeah, sorry to interrupt you, the last meeting, they didn't have a quorum, is that right, Steve?
No, I believe they had a quorum for the meeting in July.
We did?
And if you don't already have it, I'll get everybody their notes from that meeting.
They did adopt the January meeting minutes from the reorg. That was one of the objectives of that July meeting.
Yeah, and I think you being Board of Supervisors, has already accepted those reorg minutes. So, like I said, I'll make sure you have those notes from their recent meeting. And of course, look, they won't meet in August, they're gonna meet again in September.
Yeah.
Thank you, Steve. John, do you have anything else you want to add?
No, I'm just confirming on that, that those reorg minutes were accepted, so we're 6 months past on that.
Okay. Item 5, we have Parks and Rec. Christie?
There is no report.
That's an easy report. Item 6, Planning Commission.
Obviously, there's members of the Planning Commission here tonight. We'll talk about a couple of applications that were discussed at their meetings, but for this coming month, we have the Mobile 3 land development plan. It's in their final plan stage. It was granted conditional preliminary previously by the board. We also have a lot annexation plan and a variance application for a kennel that will be reviewed at that next meeting in August.
And as I understand, the Planning Commission may not have a sufficient number for the whole meeting, because they won't have a quorum. And so I'll be in touch with Gary, and we can get in touch with the people. I didn't even know we had 3 Gs. I thought we had 1.
Yeah.
I mean, besides the zoning issue. That's not as critical.
So
And
it
you
sounds
would
like-
like to see if we can get either an extension, or if they'd rather not do that, I'll let you know, and you'll see if you can.
If we have items to take action on, you ought to circulate some available dates. We should reschedule.
Yeah,
Yeah, it
so
sounds-
that's what you
it sounds
prefer
like-
doing,
Well, yeah, I don't think it's fair to push them off till the September meeting.
so we can do that.
So, I mean, we could go into the following week, or even pick another day, whatever suits the rest of the
Yeah.
commission. Well, so you'll send that out?
Sure.
Yeah,
Yep.
I'm pretty sure we're gonna be, it's probably gonna be Terry, Troy, and that might be it.
That might be it.
Okay.
So, I don't think you guys can legally do it. I don't think we can either.
No.
Yeah, send something out for some dates and we'll get something rescheduled.
So we'll also ask Christie to note on the website that the regular meeting is canceled.
Yeah,
And then once you come up with an alternative date, I'll have to re-advertise, and we'll get it up on the website.
what do we need, 5 days? Is it 5 days?
It's less than that, yes.
Okay.
Yeah, I think I can do that, in a couple of days. A couple of days' notice.
We'll get something.
So, yeah, as soon as we can get that date, I can get the meeting advertised.
And that's all I have unless the other planning commission members are going to add.
Okay.
Thank you.
Thank you. Up next, we have our open forum. We're first start out here in the meeting, and physically, anyone here on this side of the room have anything they'd like to get up and say, or talk about, or ask a question? This side of the room? Anybody on this side? No? Okay, then we'll go to our Zoom attendees. I'm not sure who's on the Zoom.
There's nobody on Zoom with the exception of John and Christie, so there's no
Okay,
problem.
okay. Thank you. All right, we'll go to page 2. The new business. First item on new business will be Mr. Samuel King, 434 Beaver Dam Road, tax parcel 22-1173, zoning hearing meeting number 2021-8 variance application.
Okay. Mr. King, you are Mr. King? Okay, I apologize for that. Mr. King is present tonight. What I typically do, Mr. King, is I give the board a little overview of what the application is. And if you have anything you'd like to add after that, I can certainly turn it over to you to add or have questions by the board. What this is, a variance application for 450 Beaver Dam Road. It's for a horse barn carriage shed. It's going to be located 30 foot off the front property line. There is a 60-foot required setback in that district. This is a 2-acre landlocked property in the RC district off of Beaver Dam Road. has a single-family dwelling and an existing barn carriage shed. What they're going to be doing, and correct me if I'm wrong, Mr. King, they're going to eventually be removing the existing mobile home, building a new house on the property, and they would like to make room for the new house and also an attached garage, which is necessitating the relocation of this encroachment into the front yard area. It is entirely wooded at this point. I don't even believe you can see it from the road that I'm understanding. So that's what the need is for the variance request, is the encroachment of that, basically 30 feet from the lot line instead of 60 feet as required. There are some other conditions on the site, steep slopes and so on, that's kind of necessitating the location of this. There was stormwater that was previously done as well, so that has already been taken care of. And I believe there's also the removal of 2 others. This is actually replacing 2 other structures on the property already. Did you have anything else to add?
The only thing I would say is, between where the 30-foot setback is, where the other landowner, I don't know if that makes a difference or not, but it's not coming to it.
So you have the other property from the setback? Okay.
The planning commission did review this, and they did offer a recommendation of support for the application.
All right, do I hear a motion to support the variance application?
I make the motion to support.
Hear a second?
A second.
All in favor?
Aye. Aye.
Thanks for coming out.
Thank you.
Okay, item 2 on the new business would be Arbor's Edge, 2351 Chestnut Tree Road, variance hearing, application number 2021-7, variance application.
So you want us to use the microphone or?
That would be
Yeah.
preferred.
And so for the people on Zoom, we are having some representatives here to make the information clear.
Good evening. Good evening. My name is George Ozarowski, I'm the attorney from Plymouth Meeting, Pennsylvania. I'm representing Sheriff LLC, who's the applicant. The owner is BOS LLC. The principal of both of those entities is Eddie Brown, who's in the back of the room today. I also have Al Rivera with CMC Engineering. Al here. We're here tonight because the applicant has filed a zoning application seeking relief from section 27503A of the zoning code concerning lot area and lot width at the street line. The property is 43.11 acres located in the mixed-use residential district. The property is located at 2351 Chestnut Tree Road. The applicant is proposing 166 townhomes. There is relief required from both lot area, as I mentioned. Required is 5,500 square feet. On the plan, it shows proposed 3,506 square feet. However, 97% of the units are actually 3936. So 97% of the units will be 3,936 feet. And the other request for the street line setback is 50 feet is required, and we're proposing 24 feet. However, again, 93.4% of the units will actually be 48% wide, and just a few of them will be smaller. And that's basically because we have a couple cul-de-sacs. And when you put the lots in the shape of more of a pie, you're going to do some of the street frontage at the street line, and they're not quite as big. And you're going to see the plan in a second. The lot itself is heavily wooded. It has a stream in it. There's some sensitive areas that cannot be developed. It's also encumbered by a gas line easement. So our plan is proposing that we were going to save 49% as green space on the plan itself, which I think is an advantage to the community. Otherwise, we're complying with all the other zoning ordinances. So it's basically just one-dimensional, two-dimensional variances. You're going to hear some history tonight. We spoke to the township several times regarding this plan. We've gotten actually approval for a special exception previously, a couple of years ago. We decided not to proceed further from that plan for just basically economic. Haven't changed since then.
Just a quick,
Yes.
was that also for this residential type use?
It was actually much heavier use, you'll see. It's actually sort of a combination of apartment buildings and townhomes.
Okay.
Yeah, sure. So we kind of ran into an issue where we submitted a plan that showed a mixed use regular houses and townhomes, and we met with staff, with Mike and Steve, and we were basically informed that that would be a considered mixed use, which would require a use variance, which we didn't want to do. So then we came in with a plan that just showed all twins. During the course of this process for several years, we've always proposed plans that were basically net lot line plans. When Mike had a chance to actually sit down with the ordinance and reviewed it, he determined that, you have to at least show that we comply with the intent of the zoning ordinance and the dimensional requirements in the zoning ordinances. As I understand it, Mike can speak for himself, but that's my understanding of what we were told. So we submitted a plan that basically showed lot lines for the 166 twins. And that's what we're here for the variance for. We also will show you a plan tonight that shows, basically takes off the lot lines. It's going to be the same 166 units with just out the lot lines. If you decide that that's appropriate, then I'm not sure we would need zoning relief then, because we're basically complying with the intent of the zoning ordinance. But we're going to go through that process, and we're going to absolutely lay that out for us and see what we're saying. With that being said, I'm going to turn it over to Al so he can give his presentation.
How much would you like me to set these plans up towards?
Just make sure that the board and Mike and the solicitor can see it.
Again, my apologies, the plans are wet, so the work will be done. Just to quickly orient the board as to where the site is at. The site is actually outlined in the dashed line of the plan. It is about 1,000 feet from 322 at the intersection of Chestnut Tree to 322. For reference, and I heard Ryan Holmes when we talked about Ryan Holmes' development is just up the street north of this site. They're developing single-family homes, and that is actually included within the township. Outside the township, there is an approved light industrial land development, I guess, in East Hampton, like that, has, I guess, started construction as well, and the land directly to the west of us is currently for sale. So we're surrounded by development, I should say, as part of this parcel. What I'd like to quickly do, as George had stated, is go through plans that we have submitted to the township over the many years. And I'll start with the plan back in 2016. This was a plan that was based upon the old zoning ordinance, which at that point was all residential. And we were proposing a very high density project. It was a total of 286 apartment units within 11 buildings or 11 blocks. And the idea here that George had stated was a zero lot line development. Basically, everything that wasn't developed was going to remain as green space. It was going to be managed and maintained by a homeowners association. And that's been the intent, I guess, from all the plans that were submitted up until the current plan that we have before the board. That plan was actually not acted upon because the zoning ordinance was changing. And the idea was that we were trying to set a plan under the new zoning ordinance that was adopted back in 2018. So we followed up with an application back in 2019. This is what George had stated that we got special exception approval on. Here before the supervisors as well as the planning commission and the zoning board to get approval and recommendation for approval on this plan. This plan proposed 226 total units. It was in the mixed-use residential district, as has been the case since 2018. It made a total of 150 apartment units and 76 townhouses. The apartments were situated in 4 buildings that were 4 stories tall up against Chestnut Tree Road, as well as 1 building interior that was 4 stories tall. The remainder were all 3-story townhouses, and we met all the requirements of zoning. And as George stated, we did decide to abandon this plan mainly because it's very hard to market apartments, I guess, in the Honey Brook area. So this plan was allowed to expire. And the new plan was submitted to the town back on March 10th, 2021. This plan was basically the mixed use or the mixed housing type that George has stated. It was a combination of twins and singles. We had a total of 118 twin homes and 67 single homes, for a total of 185 units. And what that was an 18% reduction from the plan that was approved for special exception back in 2019. Met all the zoning requirements, but at that point, it was determined that we needed a use variance because we're providing two different types of housing types. It was single family versus twins. So it was defined as two different uses, and our client decided that he did not want to seek a use variance. So that application was withdrawn, and a new application was submitted. In April 23 of 2021, it's reviewed the use variance, basically proposing all twin homes. We have a total of 230 units. There was a 20% increase from the prior plan, but just like the prior plan, the idea here was that 0 lot lines. It was not intended to be lotted out. It was going to be a homeowners association managed by that. Be simple, and that was the intent from, I guess, day one, you could say. We felt we met all the zoning requirements, but however, it was determined that we have to meet the intent of the code, therefore showing lot lines, whether they be actual lot lines or phantom lot lines, and showing that we comply at least with 5,500 square feet minimum requirement for the lots, as well as the frontage requirements, or ask for a variance. So at that point, we submitted the plan we saw, or that we have before you today. And that is the current plan with 166 units. It is all twins. It is 20% or 28% less units than the previous plan. And it meets all the zoning requirements with regards to 2 variances. This plan is a little bit revised from the plan that my client has seen and commented on. We did fix some of the, I guess, inconsistencies that he brought up. So at this point, we're looking for 2 variances. The variances are related to the front yard width. We're required at 50 feet front yard along the street line. We're proposing for, I think, 97% of the lots to be 48 feet, which is 2 feet shy. And as George had stated, most of these smaller lot widths are mainly on these 2 cul-de-sacs. As the lot lines turn to more of a pie shape, the width gets a little narrower, and that's why we're showing a narrower width for at least a certain percentage of those lots. And we're also asking for a variance on lot area. We're showing 5,500 square feet is required. We're showing a minimum of just over 3,500 square feet. But again, that is a relationship to the cul-de-sac area. And that one lot is actually located right here. Lot is very narrow at that cul-de-sac. Whereas, I think it is 97% of the lots are almost 4,000 square feet. But what's unique about this plan is that almost 55% of the units actually back on what we're considering preserved open space. 21 acres, all this green space and the easement area is preserved. So those, I guess, homes, even though they don't have 5,500 square feet, they actually have access to visibility, open space as a part of the community that is directly contiguous to their lots. And that, in a sense, is almost 50% of the land that's being preserved as open space and permanently preserved and maintained by the homeowners association, even though there are lots. And one thing that George wanted to, that had brought up was an alternate plan. This plan here is exactly the same as the plan that has been submitted. The only difference is the lack of lot lines. It would be a 0 lot line plan. Everything would be managed and maintained by the homeowners association. And we would then not be required to seek the variance relief because our one lot exceeds the 5,500 square feet for almost 2 million square feet as far as the whole lot. And the frontage would be related to Chestnut Tree Road, where 50 feet is required. We're over 750 feet frontage along Chestnut Tree Road. So the idea here is that lot lines, no lot lines. That's been the concept all along, is to not provide lot lines and not have to worry about asking for relief. One other plan I'd like to present is a village green development. This was something that was approved between 2005 and 2011. This is located right along Route 322, a stone's throw away from our site. And this was approved with the same concept. They proposed 67 townhouse units. It was located, I guess, at that point in the mixed residential district. As a part of their zoning chart, they identified what they call fee simple, which is very similar to the zero lot line. Person comes in, they buy a property, or they buy the unit, they own their unit, but the rest of the land is common ground. It's owned wholly by all residents. So it's one single lot, and it's not lotted out for each unit. So much so that they listed on their zoning chart the requirements for minimum lot area of 10,000 square feet and minimum lot width of 45 feet, but they did not comply with them, nor did they ask for variances. So that's very similar to what we've been asking for. It's basically a zero lot line plan that isn't required to have a lot lines or ask for variances.
Thanks, Al. So as you can see, there's going to be extensive amount of wooded areas that's not going to be disturbed. We do show a walking trail. There's going to be some improvements made to Chestnut Tree Road. That's going to be part of this plan as well. And we'll get into obviously land development when we get to that point. Hopefully we do. So tonight we're asking for either your support of the zoning application, first off, or in the alternative, if you are comfortable with having the same plan without the lot lines, your support for that, and in which case, my understanding, we would not need zoning relief. Because we're pretty much complying with the intent of the zoning ordinance, given the restraints on the property. And we're here for any questions that you might have.
Yeah, why did you put the lot lines in?
Well, again, we were instructed by staff to show that we would comply with the intent of the zoning ordinance. Because you don't have any necessary density requirements in your ordinance. It's not like you say it's 10 per acre or anything like that. You just have these dimensions. But your zoning ordinance, in my mind, the way as I interpret it, doesn't necessarily, you cannot do a zero lot line plan. So it's, I think perhaps maybe other applications that came before you, and the decision was, well, show us that we comply with the intent of the plan, or the zoning ordinance, excuse me, as far as dimensionals go. And that's why we propose a plan with no lot lines. At least that's my understanding.
The application that we had just looked at for, what's the last mobile home park? Home Court event? Yeah, they had also wanted to have smaller lots and not follow the ordinance.
Well, I think it's essentially your interpretation of following the ordinance is what it is. And we respected the staff's determination. That's why we put together a plan without lot lines. I mean, with and without lot lines.
And really, the unique thing about this property is that we're preserving almost half the property. There's other expense.
You mean it's not buildable,
Well,
the
portions
space
of
that
it
you're
are,
observing?
portions of it are buildable, portions of it are sensitive land and or setbacks. So there are still buildable portions of land that are not developed. So, I mean, that basically the community has access to that. That becomes part of that community, and part of that development. So even though they might have 1,000 less square feet per lot, or just 1,000 square feet per lot, they have access to 21 acres of green space as part of their community, which I think most developments can't say they have.
And the Village Green, I think, was approved under a different set of zoning ordinances, right?
It was the Elmore District. Correct.
Right. So there was different rules in effect, which would make sense of why we had different.
But typically, the law in Pennsylvania is, and I don't mean the lawyers, if there's any ambiguity in the zoning ordinance, it goes to the benefit of the landowner. It's kind of like what the general rule is. Your zoning ordinance does not prohibit zero lot line areas. It just doesn't. So we're showing us, what we're trying to do is show good faith. We put the lot lines on here, just like we were asked to do. If you put the lot lines on there, you need 2-dimensional variances just to make the plan work. But if you're okay with the way it looks, without putting the lot lines on, we'll proceed with this plan. But we need some type of decision to be able to do that.
Mike, this is John. I had a question for you on that, the review letter.
Sure.
Hey, Mike, it shows a couple things like
letter that I issued on June 29 reflects the plan of June 22nd.
In response to those questions, we did, as far as from the existing features plan prepared by another firm, we did actually get FEMA approval for redistricting of the floodplain. So our floodplain is different from what was on the existing features plan, and that will have to be updated. With regards to the parking, we are showing from a zoning perspective the required minimum for parking, which is 2 per unit. We're capable and able to provide more parking for overflow. We're willing to do that during the development process. But as far as zoning, we do meet the requirements of zoning for parking at this point.
So I just kind of want to chime in here with the board. I mean, what's before you tonight is the zoning variance application, which would be the plan that's on the left, right? And that is what
That's
has
correct.
been submitted with the lot lines from which they're seeking 2 variances that's slated to go before the zoning hearing board. I mean, with all respect to, in my mind, what you're showing on the right, telling me that you shouldn't have to do lot lines under some theory, really is a challenge to the determination that the zoning officer has already made as to how your ordinance is interpreted. And I think this, that is not before the zoning hearing board as part of the relief and the application that was submitted. There is an avenue, you can appeal the zoning officer's determination, but that hasn't been done at this point.
Yeah, and we're not necessarily trying to challenge a determination. We're just showing you that, and I agree with you, what you said, 100%. I agree with you that we're here tonight to hopefully receive the recommendation regarding the zoning application. What we're trying to do is establish an alternative way of doing the same plan. And I don't know who makes that determination. I don't know if that's the zoning officer, if that's the engineer, or if it's the board who makes the determination as to whether the zoning officer would determine if it applies to the intent of the zoning ordinance. I think that's
Technicon's the zoning officer, so I would review that as the engineer on behalf of the zoning officer for Technicon.
okay. Well, that's fair enough.
The board doesn't interpret
Listen,
zoning.
I don't mean to belabor the point either. I mean, I really don't. We're just trying to show like tonight so we get a feel for, this will be the same plan, and we're going to take this up with Mike at another date. Again, I don't want this meeting to go sideways, but we're really not issue.
No, I just kind of, I think there's a distinction there in terms of this board isn't going, I don't believe my board's role is to agree that what's on the right is right, so to speak.
Understood. Understood.
I have a question, I mean, and not to look at your plan on the right, but to the extent you're saying you meet the intent of the ordinance, I mean, if you have lot lines, you're supposed to have a 50-foot wide lot. And I mean, it's clear to me, maybe you're saying the ordinance means something totally different. The fact that those homes are, close enough to each other that if you did put lot lines in, you couldn't do a 50-foot lot frontage, doesn't seem to me to meet the intent of the ordinance. I mean, I would think, if anything, if you did that type of a layout, without lot lines and found some remedy for the avenue you're talking about, you would need to space those homes at least, an extra 4 feet apart, so you had 50 feet per lot of frontage. Does that make sense? I'm just kind of not following even where you're trying to go with that.
Okay.
That would cut us down to 25 feet.
Well,
You
right
need to
now,
understand the zoning as it was drafted.
Yeah.
You're basically at 50% lot size right
The zoning as it was drafted is backwards. The lot width at the house is 40 feet wide, and we meet that. It then goes out to 50 feet at the road, which makes no sense. When you have that, you have the reverse of that. Either the same 40 feet or less, like in the case of a cul-de-sac. So we're bumping up against that 50-foot width where it gets a little tight in places. So the relief of 2 feet, we're still meeting the 40 feet in the lot width, the normal lot width. You understand what I'm saying?
I understand what you're saying. I don't know the ordinance inside and out enough to fully agree, but I understand what you're saying in terms of dimensions in different places on the lot creating, arguably difficulty. You can't exercise the minimum at every point in the lot and still have lots that fit.
And that's why we're saying, and again, I don't mean to get, that's why we're saying we need to be intent of the code. We're trying to do a project that's consistent with what the code says.
And I think we talk too much about the plan that does not have lot lines. The bottom line is, for the last 2 years, all of our plans have been non-lot lines, and nobody from the township said anything after all kinds of reviews. So when we submitted in March, we were not aware that we were not allowed to do a zero lot plan. We found out afterwards. So what we're trying to do is take a healthy plan, make the lines fit. We can do that for the bulk of it, but we need some relief in the 2 variances that we're requesting tonight, and we're asking for your support when we go before the board.
So generally, to your question, they're not asking at this point for a variance from showing lot lines. They are showing lot lines and have submitted a zoning application that shows them. They're looking for relief to have lots that are smaller than the minimum required, and for most of them, a slight adjustment on the lot.
So that's basically what happened with Old Realty 3, right? They came in with lot lines that were too small, and then we said, no, we can't do that. And then they had to go back and redo their,
They redid them, like,
They redid their plan.
one after this as well.
Right.
That's- They need to demonstrate that they had enough to meet the minimum lot area requirement for each unit and setbacks.
right. So, we just, what was that, 2 months ago? 3 months ago?
Yeah, we've been.
Well, we go before the board Monday night, so we have your support for what we're asking for.
John, do you have anything else you'd like to add?
No, I think I heard enough at this point.
Do I hear a motion to not support the variance application?
I'm prepared to make a motion to take no position.
Gus?
I make the motion to be opposed.
I'll second
Okay.
the opposition. All in favor?
Wait, so
We're
John made a motion to take no support.
Yeah, he's taking no support. I'm opposing.
Well, I just gave you the third vote on when you asked for all, and I said aye on that motion. Say no.
Okay.
Okay. So your first motion died.
The first motion died because,
Okay.
and Travis came back and said no position. I mean, not the proposal.
Okay.
Thank you for your time.
Thank you for coming out. Okay, next would be no court advantage, which I'm not 100% sure, but I think they're out in the lobby.
Oh, she's on it?
Yeah, she's
Sorry, thanks for waiting.
Because she was there. She was there.
Okay, next we have item 3, Court Advantage Keystone Court of Oklahoma Park zoning hearing application 2021-3, amended variance application.
here. Allison Zorro on behalf of Home Courts Advantage, Keystone Courts Mobile Home Park. With me this evening are Bobby Benedicts, who is the owner of the park, and our civil engineer, Jack Robinson. The board may recall that we were here earlier this year in the winter, in February, showed you a plan for a proposed expansion of the park. And at that time, we were requesting essentially to double the density in the park, and we were requesting 8 variances. After we met with you, we went back to the drawing board literally and had worked through numerous different iterations of the plan with your staff and have submitted an amended application. This application for the expansion actually puts all, and if you recall, the park today is not conforming to setbacks, not on lots, etc. for the home sites. What we're proposing now and what we have filed as the amended application would propose 36 additional home sites. They meet all of the area developer criteria, density criteria. They're on individual lots, except for 10 of the new home sites would need front yard setback relief. And those are along the eastern property line. On the east, to the east of the property is another mobile home park. And we believe that we have justification for this variance. The site itself is irregularly shaped. There are several constraints in the back, natural features. Jack can walk you a little through the plan a little more, but essentially we feel as though this layout makes sense without encroaching into those features, and we can otherwise comply with your ordinance. So, I mean, Jack, I don't know if you want to sort of walk through, there are some other amenities we've shown on the site plan and sort of explain where the new lots are in relation to the existing lots. And do you need him to be on a microphone now that I'm thinking about this? Because this is not Zoom.
You want to say something?
It probably is best for those on Zoom for John to have.
And our recording secretary is also.
Yeah.
Okay. So, do you want to come over here? I'll be your one that is.
Yes, this site, we had reviewed this, I think, in prior meetings, so I won't be going into too much detail. But, as many of you are aware, the existing park here is 47 existing units, and they're in the shaded area that's in the front of the park. And majority of the rear, as far as the rear western side, is wetlands and some woodlands that's staying preserved as part of this project. Really the main part of the site to be developed is the rear, straight behind the existing units. What our plan proposes to do is propose a buffer around the whole site, which the ordinance requires. It's a 50-foot wide buffer. Within that buffer, we're showing a nature trail, which we've kind of discussed before. The planning commission has input on how we can interconnect that nature trail into the site a little better, which we've done. But for the most part, the nature trail runs the circumference of the site with a couple accesses in the middle. And we think that's going to help keep some of the people off the roads and actually closer to really to enjoy the woodlands in the rear and the existing trees around the perimeter, as well as just allow people to get from one place to another on the site without using a car. There's also a top lot in the rear, so again, that nature trail can be used for walking along the trail to get to the top lot. That's another amenity. As well as the existing building that's in the center, you can see a color. It's in the center of the existing park, and that building would be used as a community center. So right now, it's just a building. It was formerly a utility building used years ago, and it's really not being used right now very much. So it has a bathroom in it though, and it's about 400 square feet. Each of the lots, just so you give a little background too, has parking. So it was something we talked about before making sure there's enough parking. So each lot has 2 parking spaces dedicated to the lot, plus we have additional parking for overflow parties or et cetera, that kind of thing. So you'll have additional parking areas in various locations. And some of the major changes since we've last seen you is to add lot lines. It's one of the main things that we've done. There's formal lot lines around the site. The lots that Allison spoke about with the front yard setback are on the east side, and it's because of the existing park that you're really not able to utilize the area to the east as well. So that necessitates a setback. So you have 2 things pinching you on this side of the site. You have a 50-foot buffer, which we talked about, and then you have the existing units. So otherwise, this space becomes really useless. So that the one thing that we came up with was to provide the buffer, provide the walking trail, but then have a less of a setback along this section here. And in addition to that, we varied the units. So the units that you can see are different, almost a V-shaped pattern. So they kind of create a little court in between there. So kind of use that as an opportunity to not do a typical unit that sits vertical to the street, but actually have an open area and kind of create a little court for each of these units. And with that is a reduced setback. That's one of the major changes since we discussed last.
Well, obviously, this is a lot closer, I think, to what the planning commission had intended. I think the planning commission's recommendation previously, they haven't seen this plan. But the previous recommendation had to do with coming up with more of a typical lot layout, meeting the lot area requirement, width requirement, those types of things. So obviously, they've achieved that to some degree. Reduction in units, I believe, from the past version. So it's a lot closer to what was intended there, I believe, from the planning commission discussion. Just out of curiosity, if you would actually tweak, I know you were talking about the setbacks from the side there. Would you still need relief if you actually straightened those out? It's just I know that the ordinance talks about staggering and not having a uniform layout, which I'm familiar with, but you would still need relief, I believe.
Yeah, it would get tight. You really have to put that unit right in there, and do above along. With very little wiggle room if you're doing that. Yeah, I think this offers a better, it's going to be a much better view. You have almost a little privacy. It's going to create a much better atmosphere along the side.
The community building, is that on that?
Yes, it's colored right there.
Okay. And that's, what do you say, 25 by 25?
I think it's about 400 square feet. I was talking about it, Bobby. I think it's maybe 22 by 180 about there. Between 400 and 500 square feet. The building is. And it's been there for years. It's not a mobile home. It's a foundational structure.
And how many residents are in the park?
47 is what they're permitted for.
And then you have some in the front too, right? All together, so you have, what, 47 in the front?
And so, yeah, so all these shaded units that are existing are 47 of these.
So you're adding 47 now, 47.
We are adding now, we're adding
36.
36.
For a total of
Yes.
80.
That's where we started out, I think you said.
I think it was, yes, you're right.
Yes.
This was back, 47 and 47.
But now we are proposing to reduce, we are proposing less. So the total would be 83 under this current proposal. Your ordinance allows 60 units per acre for the site, which is, approximately 22 acres. And we are, with these additional units, we would be at approximately 4.8.
I'm just curious because I think that's, what kind of amenities are you going to put into that community center?
I think the idea for that room is about, the ordinance does require that the actual use would be likely for meetings or for small parties. If somebody wanted to use it for a party, that they didn't want to use their unit. And just community meetings, whatever was necessary, basically a meeting room. There is a restroom in there now.
But, so it would essentially be an open room, you know, 4 walls, kind of like where we're sitting.
Exactly.
One little smaller.
Multi-purpose room, yeah.
One room, one bathroom.
Yes, there's a bedroom. I don't think that would be more of a, I think the real amenities were more of the nature trail at the top lot, which is down here at the top lot. That's really more the amenities.
Oh, 83 homes though, I think then all total, right?
That's pretty cool, yes.
Yeah, so, and then you said that's about, what did you say, 40 square feet?
400, I think that for this community center, it's maybe 400 plus square feet. Existing building, it's an existing building, so we're going with the confines of that. But if something else had to be built, that would be different, but that's what's there now, a building of that size. We think it's a good location and a good use for that building that already exists.
Yeah, anyway, make it maybe a little bigger or maybe a little bit, so that maybe more residents could use it. Possibly.
It could be expanded on where it is. Yeah, it is. You're not locked in. I think the location is the best for it. And that's the side. I'm just telling you the side it is now. It certainly could be built add on. If needed, yeah.
What was that building previously used for? It was used for,
What's clear?
It was a utility building. It was like, before this development, when it had on-lot water, it was a well pump house. But now it's public water. That was years ago. It's just been a vacant room with a bathroom.
The idea would be to obviously improve it to be useful for community space.
well, I personally think, I mean, if you're gonna make a community space for 83 residents, homes, you know, that's pretty small.
And the option is to, we reject that they would have to come back with the proposal for community center and with a different location, I guess.
Well, some more details maybe, and maybe some.
Yeah, it said that, to bring that existing one up to code, we're not sure, not clear about that.
Yeah, that's
All right,
right.
yeah.
Bring it up to code, but I think it's, you know, if you have 83 homes, you just say
Yeah.
2 people per home, and then if even just one person from 83 homes wanted to go to the community center at the same time, couldn't actually get that done, which is, I don't think you could physically get in there.
I would rarely think that everybody, there's elderly people, there's younger people, I don't think you would have an event where you would have that many people.
83 people?
Do you guys have any idea what the fire code kind of would be for that size space? I have no idea, it's just a question. Anybody?
No, and I mean, our client has no opposition to providing community building. You know, it's something we can certainly, discuss in the development, the details of that. We're just showing what the building that exists now, would be a good spot for it. But, if that building can be expanded upon, I don't see that as a problem, an issue at all. I do think the location is helpful where it is now, just because it is a foundational building, very few. Everything else is alone. So it could be expanded upon. So there's an existing shed behind it that does not need to be there. So
Yeah. I mean, I like the idea that kids have somewhere to go or some type of community center or something positive. So, but I don't think that's very big for that many people.
certainly expand. Yeah, I think use would be like said, parties, that kind of thing. But the top lot has been expanded on this. We have the top lot before the front. The large top lot on this plan as well. So, I mean, for the better weather, that will definitely be a place for the kids. And there, I think, I don't know if I just skipped over this, but I did talk about this last time. There is a bus stop that exists that will be maintained out front. So that'll still be there as a very fun location.
So just on the community building, you know, the zoning hearing board application that was submitted kind of identifies the presence of that building, asks to sort of for an interpretation that it satisfies the requirement for a community building, but if it doesn't, then asks for a variance. I'm guessing, is that a variance to have no community building? Is that the intention? So I'm just trying to, you know, hear from you guys what this intention is, so the board, you know, acts and we end up with a recommendation that addresses the actual application.
Yeah, I mean, at the time we filed the amended application, there was a bit of a question as to what it would be or how it would work, so we wanted to make sure that we didn't have to file a second amended application. I mean, what we're hearing from the board tonight, it sounds like if we're able to do something that utilizes that building or finds a space on the site for it, we're obviously willing to do that. We would not proceed with that variance request, and we would withdraw it. I did talk to the zoning hearing board solicitor about that as well, just to explain sort of the context of where we were. Primarily tonight, we're looking for a recommendation, and we're hoping that you would withdraw your opposition that you had before as it relates to the front yard setback for the new plan, and I think we can work with the board and the planning commission through land development on a satisfactory community center.
So essentially, if the board wants a community building,
Yes.
they should technically, you know, not support the variance related to the community building, because the variance would be to not require one. If you want a community building on that issue, I think you should be not supporting the variance and giving them the feedback, essentially, that you want one and you think what they have there is a starting place, as long as they can work with it. You know, in some ways, they're looking for just your feedback that, you know, they can do something with what they're already working with that satisfies the requirement to this board's contentment.
Okay, and I do think that you, I appreciate that fact that you went back and, you know, wrote the plan and listened to us. John, do you have any questions?
Yeah, this was not presented to the planning commission. Was it a matter of timing, or why didn't the planning commission see this?
We seen it before, John.
No, he said the planning commission.
Actually, and I don't know if this is the answer. Gary's sitting here, maybe he knows something of the history, but I believe the planning commission looked at the first plan, and at the end of the night, their recommendation for the Board of Supervisors was to support the zoning application. However, when the plan came to the Board of Supervisors in February, the board looked at it in a different light and decided to oppose the application. So now this is the guessing part, that was what happened. But the guessing part is that if the planning commission would have been happy with the first, iteration of this plan, there's no reason why they would be unhappy with something with less density and closer to meeting all the zoning. And it's not like, Home Court Advantage was trying to skip that. It's that the discussion was between them and the Board of Supervisors, I believe, at that point.
and there's not, John, I mean, there's not a requirement that planning commission review every zoning hearing board application. We tend to do it as a matter of course, because we obviously want their feedback, in the discussion, but it's not a requirement. I think it ended up being partly just a time thing as well, when it came into the meetings.
Okay.
Do we have a motion to support item A?
I make a motion to support.
Do I hear a second?
Yeah, I'll second.
All in favor?
Aye.
And then item B would be no support or whatever,
To accept your
Yeah.
Can you clarify that?
Yeah, so right. Well, I don't know, the
I mean,
motion
I could
is
try
on
to
the
make it,
agenda.
I could try to make it easy, in the sense that if what we're hearing from the board is that you want a community building, I will withdraw that variance request. That was my intention. So rather than having you vote to not support it, we will withdraw that request and I will submit a letter formally withdrawing that tomorrow. If that makes it easier for everybody.
I mean,
Yeah.
technically, as it stands tonight, the board could just, make a motion to not, to the zoning hearing board to not grant it, but that'll basically be moved when they
Right.
approve it anyway. It may be cleaner to still take action on what is part of the application as it's before now, which is not the motion that's on this agenda. So, if that's, I would say it would be a motion to oppose the home court advantage variance request for relief from providing a community building under section 27-2106.d.
I think that's more or less the next possible motion that's on the agenda. I don't know if that's exactly what you're talking about.
Oh, it is there?
It is.
Yeah, I'm sorry, yeah.
Okay.
Do we make a motion?
John, do you make a motion to not accept as outlined in item B, the use of the existing 25 or 25 building on site as a community center, to meet the requirements of section 27-106.d.
Yeah,
I'll make a motion.
I think Beth was suggesting that you use the, correct me if I'm wrong.
Yeah, I
The
mean,
motion that's on item C.
because C is about the actual variance,
Yeah,
which is
so
going to go
whether-
away.
Item C.
Support, take no position, or oppose, and I think you're talking about opposing that variance. And then Attorney Zarro is saying that she is going to send a letter to the zoning hearing board, removing that motion later. So this will actually not be any issue for their hearing. But we still need, just as Beth pointed out, to go ahead and oppose that.
And if you guys want a formal motion sort of with regard to their opinion on the community building as it stands today, we can do a motion on that sort of outside of the zoning hearing board, because that's what the draft motion here relates to, was kind of just whether that as it currently is satisfies.
Yeah, I think we're fine with
You
the
got
informal
feedback, you don't need a
We're
formal
fine with
action.
it, Yeah.
So we'll just skip B altogether.
Okay, so just go to item C.
Yes.
Okay, item C, motion to oppose the home court advantage variance request, section 27-2106.d, to not provide a community building. Do I hear a second on that?
What was the motion? Is it support or take no position or oppose?
No, oppose.
What was the motion?
Oppose.
Oppose?
Yeah,
Okay.
item C.
I think I'll second oppose
All in favor?
Aye.
it. Aye.
Thank you, everyone.
Thank you.
Appreciate your time.
Thank you.
a motion to approve.
All in favor?
Aye.
Aye.
Item 5, motion to authorize or not authorize the manager to sign all documents necessary to apply for a zone permit required by the PA Department of Environmental Protection for the Pleasant View Building project subject to the solicitor and Technicon's approval. Do I hear a motion to authorize the manager to sign documents?
I make a motion to authorize.
Do I hear a second?
I'll second.
All in favor, aye.
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 Item 6, motion to approve or not approve the payment of all invoices prepared by the treasurer. I hear a
Make a motion to approve.
And a second, aye.
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 Item 7, motion to approve or not approve request by the NCCMA to waive the requirement for land development to construct a storage facility at the treatment plant on land that is currently impervious.
I make a motion to approve.
I'll second.
All in favor?
Aye.
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 Item 8, motion to approve 2 financial security releases as recommended by Technicon. Now, the first one, A, is, I think that's my brother, right? So I'm not saying anything. Do I hear a motion?
I make a motion to approve.
I'll second.
All in favor?
Aye.
Aye.
And that was good for A and B, right?
Yeah.
Okay. Number 9, other new business. Do we have any other new business?
We do have other new business, in fact.
Well, I mean, I suppose technically it's old business.
It's technically, I guess, all
Yeah.
business. But it's
Old
sort of
business is
the,
new business.
Which together.
It's a new action on old business. So I did just want to give the board an update on the Helm matter. I know that's been something that's been ongoing. There was a meeting on the site with Mr. Helm and his attorney on Monday, and Quinn and Candy from Technicon and myself to discuss.
You're fading in and out a little bit there.
I'm sorry, John. Basically, we had a meeting on site with Mr. Helm, his attorney, Candy, Quinn, and myself on Monday, at the request of Mr. Helm, who wanted to have us out there to take a look at how the site currently looks and try to come up with a plan for bringing everything on the site into compliance. As a result of that, they offered to, instead of going through with a full-blown evidentiary court hearing next week, to stipulate that he is in fact in violation of pretty much everything that we have deemed him in violation of, and agree to a time frame for cleaning up those conditions that would effectively be signed by the court as a court order, which is essentially what we were seeking through that court action anyway. It would be, sort of the key elements would be that all Sunday operations cease immediately, that everything in the frontage of the property, with the exception of potentially a couple tow trucks parking out there overnight, would be cleaned up within 30 days, and that the remainder of the site be brought into compliance with the critical safety issues, including fencing and clear aisle within the site within 90 days. And so Technicon's representatives thought that that was reasonable. There's a few other minor cleanup items that we discussed that would be part of that stipulation, but I would be looking for authorization from the board to enter into, for the township to agree to have us document that stipulation with Mr. Helm and submit it to the court. It is not in formal document form at this point, but I would also be asking, sort of as part of that, to authorize Steve to sign it as township manager, so it can get submitted to the court prior, as part of our scheduled court date this coming Tuesday. So I don't know if the board has questions, but that's kind of where we're at, and I often will discuss litigation in an executive session, but I know we've sort of openly discussed this, and I wanted to give the update. And it was timely, it's not on the agenda, because it sort of just unfolded over the last 2 days. I don't know if there's questions as follow-up.
John had sent an email out with
did immediately send that to Mr. Helm's attorney. He said he addressed that with Mr. Helm. The story was he was trying to get things cleaned up for our inspection the next day, and the neighbor was running equipment. You know, at the end of the day, I don't know that this is a solution that means he doesn't ever, you know, screw up, but at least this would get us an enforceable court order that gives us a very clear something to go straight back to the judge with to seek, you know, orders of contempt of court, sanctions, etc. Because he's agreeing to very specific kind of things to occur, and if they don't, you know, we're fully in the court's jurisdiction. What this does save is us having to, you know, have a day of evidence produced, you know, just providing these facts to establish, I'll call it the problems. He's going to admit in writing that he's in violation on all of this.
You are 100% sure that he's actually going to do that?
That he'll sign it? I'm not 100% sure. He agreed to do so. I mean, if he does not, we will appear at a hearing and go through that. But the plan is that in the next day or two, that document will be prepared, finalized, and shared with him, with his attorney, to have it signed by him. And so if the township authorized, you know, the township signing it is effectively, you know, only half of the equation. He has to sign it for it to be effective, but he's indicated that he would.
Or can we pursue both avenues at once? You know, because I believe if you let off one thing, it would just be another delay tactic.
Well,
I mean, could you still keep the other existing court date and then
well,
also
I mean,
have...
we would, yeah, we're not canceling the court date unless this
Unless
gets
you have the document
executed.
signed.
Absolutely, yeah.
And that's legal.
Yes.
Okay.
Right, we are pursuing both paths until this document is signed by both sides. But if it is, that is sort of that's what we will present to the judge to get it.
I think what Christie was just saying that it's the enforcement part of that we just saw he agreed 2 weeks went by, they were quiet. Third week he is out there and then telling us that he was cleaning up the property, but you haven't proven, you know, over a course of time that you abide by things, and so if we get past this point, we sign the agreement, and in 6 weeks, 6 months, he's causing disturbances for the neighborhood, what are we going to do?
We go right back to the judge that signed this stipulated order and file a motion that he's in default and get it right back in front of the judge again. And there's nothing that's going to stop us also from filing citations at the district justice, because this doesn't eliminate individual, you know, day-by-day violations. It gives us sort of two tools in our toolbox going forward.
The penalty has been court-imposed fine, that's the relief.
That's all that's available through the district justice. Through the county court action that everything I was talking about would be part of, there are additional, you know, the court can impose whatever sanctions, fines, you know, if he is in contempt of the court order, contempt of court is in fact punishable by imprisonment. I mean, I don't see a judge doing that on the first go-round, but, you know, that level of enforcement has many more tools that a judge can throw at him if this, you know, a citation is only one moment in time and one fine. And so you can file a citation every day, but that is exhausting. The county court, you know, every time is sort of a new, technically prior violations aren't part of the equation, whereas, you know, with the county court process, that court docket will remain open as something that we can always go back to, and all of the history will be part of, you know, what comes to play in an enforcement action down the road should it be necessary.
So, I have a question just because I want to make sure that I understand this. So if his lawyer says, yeah, you are guilty of every zoning violation that exists for the
Well,
general.
they're not zoning violations.
Well,
that's
ordinance and every ordinance for the junkyard, everything that they have in writing, you've done now. And he signs that. And then, yeah, like John's saying, like 8 months from now, he then puts a bunch of equipment out in the front of the fence again and says, I don't care what they say. Then we just go right back to that document and then we can say 8 months later, hey, you're in contempt of court.
Yes,
What about a year and 8 months later?
yes, yes,
Yeah.
yes, yes.
Part of, yeah, good point there. One of the problems is that he's blocking the road. He's got, moving equipment around and, putting stuff out on the street while people are trying to go up and down Coupler Road. And this has been ongoing. The one concern I have is, I understand he's been there a number of years, the family's been there for a number of years, but this area is getting built up. And, you know, as far as the environmental impact or anything like that, have we looked at that? Not to go after the guy, but, I mean, there are concerns that he's been there a number of years. You know, the safety of that site and for the surrounding properties.
The township has taken no investigative environmental, process at this point. The use is, I'll use the word grandfathered from a zoning standpoint. It has been there for decades. It predates our zoning. That property has a legal right to continue operating as a junkyard from a use standpoint. And so what we are enforcing is our separate junkyard ordinance, which kind of dictates what that use has to look like from a health and safety standpoint. And so as to the frontage of the property, John, and the blocking of the road, I mean, for the most part, my thought is that if all of that material is not out in the front of the property, outside of the fence, where it's all legally required to be kept inside, there is in fact room for a vehicle to pull off the road, and so your road blocking problem should not exist. I mean, I think that's where that problem is coming from. I mean, the day of our inspection, there was pretty much one place that I could put my car that wasn't on Cupola Road.
I think what it really comes down to, he just doesn't have enough room left on the property but to use the road. You know, we have certain responsibilities, but is it the county that should be looking at, the environmental impact? Could it be?
Ron, there was one investigation done by DEP based on a resident complaint that was popped up with the township office. It was turned over to DEP. I don't know what happened with that particular incident, but DEP has at least investigated one incident that I'm aware of.
Okay. And they did find it? They done nothing, or do we have an indication of what happened with that?
We don't know.
Okay, we find out.
We can sure ask.
Yeah.
Well, one of the neighbors also said something to me who is downstream from there and is worried about what he's watching downstream. And I think we should find out and follow up because, that's a big deal if you live downstream from that.
Yeah, I don't disagree. I mean, one of the provisions of our junkyard ordinance absolutely relates to, proper handling of diesel fuel and those types of materials.
You're not allowed to just spill the engine.
The hard part we have as code inspectors going out there on a given Tuesday is, they're not environmental DEP groundwater contamination experts to necessarily identify.
Nor do we have regulations that we can enforce.
Right. I mean, if we caught him in the act or saw something that was a clear violation of how he was handling those,
But who does enforce that? Do you know who enforces
DEP, and that's where
And any resident can make a complaint to DEP.
Yeah.
Whether they follow up on it or not, that could be a challenge. I've had several times when I've gotten involved in other townships with DEP, and they've literally told me we don't have the resources to go investigate, so we're not investigating. So I've had that happen already, but if there's a significant issue there with pollutants, they will follow up But again, it's under their jurisdiction to do so.
Yeah.
You know, if there's clear, if there's a real concern based on something substantive and people continue to hound them, I mean, I think certainly with someone like DEP, the squeaky wheel tends to get the grease.
Well, because wouldn't we be a little bit of a bigger squeak because we are the township?
Not necessarily.
All no? Wow. Because it, like, I think he did run out of room, right? And if he just pushed everything back there, potentially in the middle of a stream or whatever, you know, whatever, he just, you know, there's no room. You know, somebody should go and make sure we can get the,
All right, so I guess what we found out tonight that there is movement on coming up with some agreement going forward. Hopefully that thing will stick. As far as any environmental issues, that's something again that the township does not have the authority or to handle, but it's up to the residents to follow up with DEP. Did I hear that correctly?
Yes.
Yes.
Okay,
So,
thank you.
so what I would like from the board, if you're agreeable with going down that path, is essentially a motion to, you know, for the authorizing the township to enter into a stipulation with Mr. Helm regarding the violations and bringing the property into compliance in that litigation matter, and to authorize the manager to sign that agreement on behalf of the township.
okay. Yeah, I'll make the motion to authorize the township manager so that he'll try to come up with some type.
Should I speak to this?
That's fine if you choose to.
Speaking.
Do I hear a second?
Yes,
All in favor? Aye.
aye.
Okay, thank you. We'll keep you posted.
What we just discussed, this is being recorded, so how, okay, so we'll have it on YouTube, is that correct? Just wondering, the Zoom recording, is that available if anybody wanted to listen to it?
We only keep those until after we have the minutes completed. And because it is only audio and it's not really that good.
All right.
But Scott's, I mean, that goes up on YouTube and it's there forever.
Yeah, yeah. Okay,
Okay, do I hear a motion? Oh, I'm sorry, let's go back to open
all
forum.
report, yeah.
Yeah, does anyone on the right side have anything they'd like to say here in person? No? Anyone on this side? No? Anyone on Zoom? John?
Nope.
Christie?
Nope, good.
Okay, can we do a motion to adjourn?
I make a
Next
motion.
motion.
All right, all in favor?
Second.
Aye.
Yeah, aye.
All right,
Good night.
upcoming meetings.
Upcoming meetings, yep.
Yep, upcoming meetings, August 16th, zoning hearing board, 7:30 PM, for variance applications submitted by Samuel King and Arbor's Edge Residential Land Development. August 19th, Parks and Rec. August 26th, probably is canceled and gonna be reconvened at some point once everyone looks at their schedules. September 1st, Board of Supervisors workshop. September 8th, Board of Supervisors meeting. That's it.
Good night.
Good night.
Good night.
Good night.
Good night, Joshua.